key mission, I think, is to be a forum for creative thought about the role of appellate courts and their influence on the development of the law, and that, in turn, makes us a forum for scholarly exchange about those broad and important topics in our society. All of that is done within the context of a faculty-edited publication, which gives our authors the benefit of the breadth and depth of our experience and our professional judgment.
It was all Tom Sullivan's idea. I have to give Tom all the credit. Tom has been an appellate lawyer for a lot longer than I've known him, and he's a great scholar. And he noticed that there was not any kind of a national law review that was dedicated to appellate matters, appellate issues, especially the practice of appellate law and procedural aspects of it.
The entire appellate community was in need of a scholarly publication that addressed topics that were of particular interest to appellate lawyers, appellate judges, and scholars interested in the work of the appellate courts. Before this journal was started, that work was out there, but some of it was here, and some of it was there, and some of it was over here, and it was very hard to find a coherent body of appellate scholarship. So following the model that Professor Sullivan set up initially, we now have an audience, an avid reading audience that consists of every appellate judge in the United States, the judges of the Supreme Court of Canada, appellate lawyers across the country and some outside the U.S. as well, but among them are all the members of the American Academy of Appellate Lawyers and members of the American Bar Association's Council of Appellate Lawyers and the members of the New York State Bar Association's Appellate Practice Committee subscribe. And then we also have subscribers, virtually all of the academic law schools in the country subscribe, and we have a number of individual legal scholars who subscribe. So we reach all three of those communities, judges, lawyers, and scholars interested in the work of the appellate courts and actually conducting the work of the appellate courts. And we are sensitive to the similar and yet somewhat varying needs of those.
Part of the idea about starting the journal also had to do with producing a publication that was really targeted at its audience. We wanted this to be the kind of a journal that appellate judges and appellate lawyers would enjoy reading, would learn from, and would want to contribute to. And so one of the things that we did from the very beginning was to look for authors. Back in the early days, we had to go look for authors because no one we knew we existed, but to go look for authors who had something to say to that audience. Another thing that was really important to us from the beginning was getting this journal in the hands of everyone. That was important to that process, getting it in the hands of the judges and getting it in the hands of the appellate lawyers. And so some very generous gifts from the Donaghy Foundation, from the Williams and Anderson Law Firm here in Little Rock helped us initially, as we got off the ground with this, to be able to send the journal when we finally produced our first issue. To be able to send the journal to every appellate judge in the United States, state and federal, from every justice on the United States Supreme Court to every state Supreme Court justice to every intermediate court of appeals judge in the country.
One of the great pleasures of working on the editorial board of the Journal of Appellate Practice and Process is that it's a learning process every time. It's a peer-reviewed journal, and we don't just edit for style or site check. We edit for substance. So if you are editing, if you're the articles editor for one of these articles, you're going to learn something. You're going to dig into those sources.
I think that mixture of confidence and humility when you're dealing with a professional editor can help the scholarly author herself to make her work much more crisp, much more clear, much more direct, and much more likely to be useful to the other scholars, the judges, and the practicing lawyers who read it.
One of our goals from the beginning was to produce the kinds of articles that appellate practitioners and judges needed. And so it really shouldn't be any surprise, particularly with judges, that as they read things that are relevant and useful and that were well written and memorable, that they would insert citations into the judicial opinions to the places where they got these ideas or these inspirations. And so I think that was the earliest kind of citation, that cross-fertilization that we saw. Of course, once judges start writing about particular journals, or they cite one journal over and over again, then the more discerning appellate lawyers and scholars for appellate law take notice. And I think that when they realize that who this journal is going to, it still goes to every appellate judge in the United States, and it goes to a number of appellate judges in other countries as well who have requested receiving it. When you know you have that kind of audience, this is a place you want to publish. And if you've got the top scholars, they're all reading one another's work and they cite one another. And so I think that's what has contributed to it.